Welcome back, Law Kids. Welcome to your lesson on charter limitations. In our last lesson, you learned what charter rights you are guaranteed in the constitutional document, the Charter of Rights and Freedoms. You learned about your freedom of religion, freedom of expression, your equality rights, how to get those rights enforced if they're violated, search and seizure law, all of that good stuff. Now for the bad news. So the Charter is an excellent document and it's really rich and it guarantees your rights and freedoms. But your rights aren't absolute. And that's what we're going to get into in this presentation. There are times when the courts will allow the government to limit your charter rights and, in fact, to violate them. How could that possibly be in a free and democratic society? Let's find out. So the first thing that you need to understand is that, yes, of course, you have rights and freedoms, but in most democratic societies, those rights are never completely absolute. You don't have the right to spread hatred. You don't have the right to, the famous analogy that they always give in law school is you don't have the right to run into a crowded movie theater and yell fire and then cause mayhem and panic and people trampling each other and injury. Like if you do that, you'll be arrested. So there are cases where your rights or your freedoms can be limited. And in the Charter, there's two sections that give the government the power to limit your rights. And so we're going to look at them. They're both very different from each other. And I think in a nerdy kind of way, kind of interesting. So the first section is section 1. So it's kind of interesting. Like you get that intro to the Charter of like, okay, supremacy of God, rule of law. And then point number 1, which is before we tell you what any of your rights are, we're going to tell you that we can limit your rights. It's kind of rude. But there it is. It's nice, actually, that it's right up front. At least the government's being honest with you. So here's the text of what it actually says. And we're going to break this down into these sort of 4 sections. So it says the Charter of Rights and Freedoms guarantees the rights and freedoms set out in it. So it's like, okay, it's a document, guarantees you some freedom. Subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Okay, that's a lot of big words, and we need to break that down. So let's do that. So we start from this premise that in a democracy, there has to be some give and take in order to ensure that everyone's interests are balanced, right? That's what that says. So we talk about that, my right to swing my hand ends where your nose begins. So there has to be balance between the rights of the community and the right to public safety versus the rights of individuals. So what section 1 does is it allows the government to pass a law that may infringe a charter right, but they allow it because it's believed that it's necessary for the benefit of society at large. And so section 1 cases will always involve individual freedom versus the rights of the community. And that makes them interesting. So let's break down the language. What does it mean prescribed by law? So let's remember, the Charter doesn't protect you from other individuals. It only protects you from the government. So if the government has prescribed or passed a law or a regulation, and that law or regulation violates the Charter, then you're going to invoke this. And then the second thing it says is that those violations can only exist if they can be demonstrably justified in a free and democratic society. So the government is going to have to make the case that it's a reasonable violation of your rights, and that kind of violation takes place in most democratic countries, that in any free and democratic society, we regulate speech and we don't allow hate speech. And if you were to look to other democracies, you would see, oh yeah, they're doing that too. So that's what that section means. So let's wrap our heads around this by studying an actual case. And guys, studying cases is how you learn law. And there is no case in Canadian law that is more important than this one, so pay attention. It's also kind of funny and quirky and unusual. It involves hash oil, so stay with me. So there's a 23-year-old guy named David Oakes. He's a construction worker. He's had an injury before, and he's arrested by police. He's found to be in possession of a large quantity of hashish oil and then a whole bunch of cash. Now, he claims that the drugs that were in his possession were for his use only, and that he used them for pain relief because of a workplace-related injury. And then when they asked him, okay, like, why are you carrying $600 in your wallet? He said, oh, well, I just cashed my workers' compensation check. They didn't believe him. They believed that the quantity of drugs that he had and the quantity of money that he had meant that he was probably trafficking. So the issue then, when the case finally made its way up to the Supreme Court, the issue was not about whether Oakes was guilty. It was about the legislation, the Narcotics Control Act, which it was then called, and how it treated David Oakes. See, it had this unusual provision in it called a reverse onus. Remember, we've talked about onus as another word for like the burden of proof. And normally in any criminal case, the Crown carries the burden of proof, right? You don't have to prove you're innocent, remember? The government has to prove you're guilty. Well, except there was this little tiny clause in the Narcotics Control Act that said, but if you're in possession of like lots of drug paraphernalia and lots of cash and large amounts of drugs, then we're going to presume that you're in possession of all of those things for trafficking. And it flipped the burden of proof over to the defendant to prove that they weren't going to traffic. Well, think about this from a legal point of view. How do you prove that you were not going to do something? It put Oakes in a really bizarre situation. There was really only one possible defense that he could use, and it was a little bit ridiculous. It was the, yes, Your Honor, I was going to smoke it all. It was all for me. Well, that's awkward. But aside from the fact that it's awkward, this reverse onus violates one of the principles of fundamental justice, which is that you're presumed innocent until proven guilty. The government said, well, no, this is a reasonable limit. And Oakes' lawyers were like, hell no, it's a violation of the fundamental principle of justice that you are presumed innocent. And so this was the battle at the court. And the Supreme Court was asked, is this kind of limit on the rights of an individual a reasonable limit? Can it be justified in a free and democratic society? And to make a long story short, the judges said, in Oakes' case, no. But there may be other cases where such a limit would be reasonable. And we're going to lay out a framework for future cases. Because remember, Oakes' case comes up in the mid-1980s. It's the first time that Section 1 has actually come up. So they know this is a big deal. And if they're going to say that rights can be limited as long as it's reasonable in the future, they've got to come up with some sort of formula or test that can be used in the future. And that's exactly what they do. So they come up with something that is now commonly referred to as the Oakes test. And so in Canadian law, if you want to find out whether a limitation of a charter protected right is reasonable, you ask sort of three questions that were laid out by the Supreme Court judges in Oakes. Or you look for three things. First, you have to look for proof that the law itself had a pressing and substantial objective. So the Supreme Court isn't really going to tolerate any cases coming in front of it for like minor, Highway Traffic Act offenses. It has to be a big, important law. And secondly, the means by which they violate your right has to be like rationally connected to the objective. So, you can't do a random rights violation for something that has no connection to what's actually going on. And then thirdly, if you are going to impair rights, you have to do it as minimally as possible. So you can't take away tons of rights. You have to take away the least amount of rights possible. Let's look at how this played out in the Oakes case. So first we look at the objective of the act, right? So what's the objective? It's to stop drug trafficking. Is that a pressing and substantial objective in Canadian law? I'd say so. Yeah. We need to fight, the mass trafficking of really harmful drugs. Is it important enough even to justify overriding a charter? I mean, I'm using a meme here. Drugs are bad, okay? But seriously, drug trafficking and drug-related crime and the addictions caused by drugs, they're serious issues in Canadian society. So it passes the first part of the Oakes test, no problem. Let's look at the second part. The measures adopted in the law have to be carefully designed to achieve the objective in question. So when we look at Oakes and we look at the Narcotics Control Act, does presuming that someone is guilty help the government to reduce drug trafficking? No, not at all. If we were to flip this over for a second and look at an issue, say, of trying to fight drinking and driving, and you look at sporadic ride checks, right? And you say, so we're not going to stop every driver on the road. We're going to stop a few drivers at random and spot check in an effort to reduce drinking and driving. Would that be minimal impairment? No, that'd be okay. But presuming someone guilty, that's A, it's not rationally connected to the objective. And B, part three, it's not exactly a minimal impairment. Presuming someone guilty is like kind of the biggest impairment you could possibly get when it comes to fundamental rights. So, no, that won't stand. So, to review, what is the Oakes test? Well, it's the case of R.V. Oakes. It is one of the most important decisions in Canadian law. It's a major precedent that was decided, and it's been used, that says 1700, I'd say by now, probably about 2,000 times. So if you're going to practice charter law, you got to know Oakes. So, and you understand a legal precedent. Now, this is a test. So, and by the way, it's been modified several times and it's been updated in future decisions. But this is the legal test that's now used anytime the government has to justify a charter limitation. And it says there, sorry, in the corner there, it's based on a balance of probabilities, this attempt to try to balance the individual rights and the rights of the society as a whole. Okay, so who cares? Like, what's the big so what? What's the now what? Well, like I said, the Oakes test is used anytime there's discussion or debate about the use of the word reasonable at the Supreme Court. And since the Oakes test came into practice, there's been an interesting thing about the burden of proof. So in a charter case, if you're going to claim that the government violated your rights with its law or policy or regulation, the burden of proof is on you to show that the right was infringed. And then the burden of proof is on the government to show that the infringement is justified. And that's a little bit more balanced going forward. So Oakes really set the stage for the conditions under which a charter violation could be justified by the government. Then we have Section 33, and it's a whole other story. So this doesn't come from judge-made law. This comes from constitutional law written by the people who were around the table that David Lepofsky sat at, premiers and the prime minister, talking about what should be in the charter. And the thing that you have to know is that in 1980 and 1981, not everybody was in favor of even having a charter. And I know that for you as charter babies, maybe that sounds like a strange idea. But we've talked before about the idea of parliamentary supremacy versus constitutional supremacy, and there was tension between the two. Trudeau's Liberals believed in constitutional supremacy, but a lot of conservatives, especially a lot who held close ties to sort of British parliamentary tradition, said, no, we don't need this kind of document. It's going to start a whole new kind of law and litigation, and Parliament is the group that's elected by the people, not the courts. We need Parliament to have the last say. And these two groups were locked in a conflict and could not get unlocked. And so Section 33 was an attempt by the government to create what lawyers love, a tiny little loophole through which governments could have a safety valve, for want of another explanation, to allow governments to violate the charter in some circumstances. So, bottom line, it's incredibly controversial. Every time that it's been used, it's been controversial. And the other thing that's kind of quirky is there's no equivalent to this section of our charter anywhere else in the world. If you look at other constitutional documents, they don't have anything like this. It's a bizarrely Canadian thing. So let's get into it. What actually does it say? So all it really says is that a federal government or a provincial legislature that if they want to, they can override the charter, right? And it doesn't say they can override any section of the charter. It just says that they can violate section 2 and sections 7 through 15. So it's not so bad, right? Pause the video here to go look at what's in section 2 and what's in sections 7 through 15. No, like really, pause the video, go look. Did you actually look? So yeah, all they can do is violate your fundamental freedoms, your legal rights, and your equality rights. What? How can this? Okay, how? Well, so they gave them the escape valve, but then they put some interesting restrictions on the escape valve. So if you're going to violate the charter, you have to say straight up in the beginning of your law, hey, we know we're violating the charter, this section, we're doing it anyway. So they're not letting you hide and do it in a sneaky fashion. You have to actually come right out and say it. And then the other thing that's interesting is that your ability to violate the charter only lasts for 5 years. And then it expires. So this puts any government in an interesting position because, of course, what has to happen every 5 years? An election. Now, I don't know how much you know about politics, how much you paid attention in civics, but I know a lot about politics, and I know that if I was campaigning, I would not want to run under a slogan, vote for me, we violated the charter. Like, that's not really a good slogan. It's not. So it's very rare that it's used at all. It's kind of weird when it's used. And there's been a couple of times where governments used it and then it turned out they didn't need to. So the first time that it was used, of course, was in Quebec to protect the French-only sign law that violated freedom of expression. And their argument was that it was needed to preserve the French language. Interesting, the violation happened. It went for 5 years, and then a new government came in and they didn't renew the law. It was used in Saskatchewan in the mid-1980s for some back-to-work legislation, and then that was really embarrassing because when they went to the Supreme Court, they were like, yeah, you didn't need to use the notwithstanding clause for this, whatever. They also used it in a dispute over Catholic school funding. Alberta's use has been really controversial. So the first was in 1988 over something called the Forced Sterilizations Act. And yes, that law is as scary as you think it was. It was a law that gave the provincial government the ability to forcibly sterilize, to make sure that someone could not have a baby, anybody with a developmental disability. Sit with that for a second. Then take in that after decades of this practice, disability rights activists rose up. They sued the government for the forced sterilization, and they won a multi-million-dollar settlement. And then the Premier of Alberta tried to use the notwithstanding clause to get away with not paying them because he said their deficit was too big and he couldn't afford it. That didn't go over well with the public, and it was an interesting example of when the law doesn't force somebody to do the right thing, public opinion does. So the Premier in this case got absolutely vilified in the media, and the pressure just got stronger and stronger and stronger until he withdrew it. Different Premier several years later under the Marriage Act, they tried to use the notwithstanding clause to get some sort of exception that they wouldn't have to have gay marriage in Alberta. That didn't really work. It's a much longer story than that, but I'm seeing how long I've already taken here. Ontario, Doug Ford said that he was going to use the notwithstanding clause back in 2018 if he had to cut the size of Toronto City Council. Then he went to court. Turns out he didn't have to, so weird. Probably, I think the most interesting use of the notwithstanding clause has come to us from Quebec, both in 1988 and more recently in 2019 with this Bill 21 that restricts the wearing of religious symbols of faith by public servants. So that use of the notwithstanding clause is really, it's still alive and still active. And we'll head to the Supreme Court in the next couple of years, and you guys will get to watch that unfold. So here's the thing. Do any non-lawyers really understand Section 33? Really? No. The average Canadian probably couldn't even tell you what Section 33 was about. So now look at you. You're in grade 11 law, and you can say you've actually heard of it and that you maybe have a vague understanding of what it means. That's really all I'm going for here. Gosh, that's a cute kid. So thanks very much for listening. And I look forward to hearing your questions about all of this. Thank you.